The gentleman from Maryland is recognized.
Thank you, Madam Speaker. Mr. Issa, I rise in opposition to H.R. 1526. I heard the majority was bringing legislation forward to clean up a major policy crisis taking place within the first 100 days of the Trump administration. And that sounded pretty good to me because we're drowning in crises. The problem is that this bill does not address any of the real major policy crises of the first 100 days that Trump has caused for America. They are wasting our time with this bill by misdiagnosing and mislabeling the judicial response to these crises as a crisis itself. The whole country is reeling right now from the economic disaster Trump has plunged us into. He destroyed more than $10 trillion in American wealth in a single week, and then he went golfing and bragged to America about winning the tournament at his own golf course. That's like bragging about being endorsed by your own campaign manager. So much winning. The country can hardly stand how much winning Trump is doing for himself and Elon Musk and his billionaire cabinet. Perhaps he could have yelled "for" on the Greenway so tens of millions of Americans could have taken our retirement savings out of the stock market before he hit us in the head with a golf ball. Trump's ruinous tariffs have crushed our relationships with democratic allies and loyal trade partners like Canada, Mexico, the UK, Germany, France, while delicately carving out an exception for Trump's friends in the Home Office back in Russia. When asked why Putin uniquely escapes the wrath of Trump's global trade war, we're told it's because Trump doesn't want to interfere with the negotiations taking place between Russia and Ukraine for a ceasefire, an explanation that might have somewhat more force if Trump had not made sure that the tariffs do apply to Ukraine, as they do. The basis for this most imbecilic and destructive trade war in the history of the world is the profound economic research and policy writings of one Ron Vera, a completely fictional economist conjured up by Trump advisor Peter Navarro, a real person who Elon Musk just called, quote, a moron and dumb as a sack of bricks. Navarro's last name, delightfully, is an anagram for Ron Vera. You can try this yourself at home. Navarro turns into Ron Vera. Navarro figured that out himself, perhaps the greatest achievement of the Trump administration so far. What an enchanting and clever basis upon which to crash the economy of the United States of America. Well, despite the fact that Congress, not the president, has the power to regulate international commerce and legislate tariffs, our GOP colleagues don't even want to have one hearing on the breathtaking economic folly and wreckage of this fling into the abyss of trade war with the world. Much less do they want to do anything to reverse this policy nightmare for tens of millions of business people, farmers, workers, retirees, and consumers being throttled by this historic self-inflicted wound. No, today they want to talk about the real emergency, which is the power of United States district courts to issue universal injunctions rather than just injunctions that apply to the specific parties in the case. It seems like a rather boutique and esoteric issue to raise in the middle of an economic catastrophe that they just foist upon America, but there's a method to the madness. You see, federal judges have issued at least 68 court orders that block or pause the administration's lawlessness to prevent irreparable harm in the country from his unconstitutional actions. The judges deciding here were appointed by 5 different presidents, both Democratic presidents and Republican presidents, in 11 district courts across 7 circuits. The judges have explained in painstaking detail what is unlawful about Trump's executive orders and actions. Trump has offered no substantive critique of their legal reasoning, but he and Musk still want the judges impeached. They say they should be removed from office simply for striking down the president's illegal policies, which is odd given that Trump and his party demanded for 4 years that federal judges strike down President Biden's policies like student loan forgiveness or immigration policies or EPA action on climate change. They seem to embrace Marbury versus Madison and judicial review of Democratic presidential actions, but not of Republican actions. Well, they say that's because Trump just won an election. He beat Kamala Harris by 2 million votes. Well, guess what? Joe Biden beat Donald Trump by over 7 million votes. And that didn't stop them from suing to stop numerous Biden policies they thought were unlawful. Sometimes they won, sometimes they lost. It's the same now. Nearly 160 cases have been brought against Trump and Musk's actions. Trump's won some and he's lost some. But our colleagues protest that Trump is different because the courts have issued relief in at least 57 different cases, a record number of cases in American history at record speed. True. But if it seems like an incredible number of cases to lose in less than 100 days, recall that Trump is engaged in a record number of illegal actions at a breathtaking velocity never seen before in U.S. history. As of today, he's already issued 111 executive orders in less than 100 days. Biden issued 162 in all 4 years. Trump can issue as many as he wants, but he's got to make them constitutional, because if they're not, they're going to get struck down. And when Trump denounces the judges as radical left judges and lunatics who've gone rogue, like Judge Boasberg, he's just advertising his complete ignorance of the federal bench. Judge Boasberg is the chief judge of the U.S. District Court, first nominated to the bench by President George W. Bush, who was Justice Kavanaugh's roommate at Yale and a pillar of the conservative bar. We've impeached only 15 judges in U.S. history, always for serious misconduct like taking bribes, embezzlement, corruption, habitual drunkenness on the bench. Never because of a doctrinal disagreement. Never because of a judge's legal ruling. As Chief Justice Roberts said a few weeks ago, the proper response in our democracy to a judicial decision that you disagree with is to appeal the ruling, not impeach the judge. And Donald Trump has gotten some relief in some of his cases already. The system's working. We don't need to turn the whole world upside down to distract from the economic calamities they've brought upon us. And all of this would be fun and games, except the rhetorical assault by Trump and Musk and our colleagues against the judiciary has turned into something far more sinister in some quarters. Death threats, bomb threats, online intimidation and harassment of judges. These judges are currently targets of an onslaught of social media taunts and attacks that call for their exile to Gitmo or label them a national security threat or traitors. Even worse, this campaign of vilification has spread to their families, including attacks on a federal judge's daughter who had her photo in place of work posted on a social media site by Elon Musk to his 290 million followers. These threats followed an actual bomb threat targeting the sister of Supreme Court Justice Amy Coney Barrett. It's a dangerous situation. Well, now our colleagues want to pass the No Rogue Rulings Act, which would effectively ban federal district courts from providing nationwide relief against unlawful actions by the administration. Litigants could request injunctive relief only with respect to themselves. So, for example, if the president establishes a church or bans newspapers or imposes martial law, each citizen in America would have to bring his or her own case, because the courts would not be able to rule to strike down unconstitutional action generally. That is patently absurd, and we're going to be able to explain how this legislation is a massive distraction from the issues that are really facing America. We reserve.
Members are reminded to refrain from engaging in personalities toward the president. Chair now recognizes the gentleman from California.
Mr. Speaker, I ask unanimous consent that the CBO estimate for this bill be included in the record.
Objection?
Mr. Speaker, I now yield 2 minutes to the gentleman from North Carolina.
The gentleman is recognized.
Mr. Speaker, thank you, Mr. Chairman. Mr. Speaker, all across the country, at record level, activist judges are impeding President Trump's America's First agenda with nationwide injunctions in depriving the American people of the changes they demanded in November. To put how unprecedented this is into perspective, President Trump has faced more than twice as many nationwide injunctions as Presidents Bush, Obama, and Biden combined. In addition, more than 90% of these nationwide injunctions have been issued by Democrat-appointed judges. I'm calling this what it is: weaponized political lawfare. There are 677 district court judgeships nationwide, and as of now, if just one of these judges decides to block an executive action, they can single-handedly halt the president's agenda. I'm sure our founders did not envision this extreme constitutional overreach from the judicial branch. Fortunately, Congressman Issa's No Rogue Rulings Act will correct this discrepancy by ensuring that district court judges cannot issue nationwide injunctions. The American people demand sweeping change from us, from cutting waste, fraud, and abuse in our bloated federal government, deporting the millions of illegal alien invaders. We need to make progress. Right now, a single district court judge can impede this progress on a whim, essentially holding the America First agenda hostage indefinitely. This must end. I strongly urge my colleagues to join me in voting yes on the No Rogue Rulings Act to stop this judicial tyranny from harming the American people. And Mr. Speaker, I yield back my time.
I reserve the rest.
The gentleman reserves. The gentleman from Maryland is recognized.
I yield 2 minutes to the gentlelady from Washington, Ms. Jayapal.
The lady is recognized.
Thank you, Mr. Speaker. I rise in opposition to H.R. 1526, a bill that would prohibit district courts from issuing nationwide injunctions. My colleagues on the other side of the aisle want you to believe that somehow these nationwide injunctions being issued by courts across the country against Donald Trump's illegal and unconstitutional actions are unfair. Well, here's the message. If you don't like the injunctions, don't do illegal, unconstitutional stuff. That's simple. Nationwide injunctions play an essential role in protecting our democracy and holding the political branches accountable. Without them, thousands or millions of people could be harmed by these illegal or unconstitutional government policies. Just look at Donald Trump's attempt to end birthright citizenship. In a lawsuit brought in my home state of Washington, a Reagan-appointed federal judge, not a Democratic-appointed federal judge, a Reagan-appointed federal judge ruled that the order was, quote, blatantly unconstitutional because the 14th Amendment plainly states that, quote, all persons born in the United States are U.S. citizens. What's next? Stripping citizenship from U.S. citizens? That's in the Trump extremist playbook as well. So is apparently kidnapping and disappearing people, including those with legal status, without any due process, or getting rid of entire departments established by Congress, or suppressing freedom of speech and dissent. These are the hallmarks of an authoritarian who wants to hold all power. And the courts are doing what they are supposed to do, issuing nationwide injunctions against this kind of abuse of power. Somehow my colleagues never complained about nationwide injunctions when dozens were issued against former Presidents Obama and Biden. But now that it's against Donald Trump, they want to rig the rules to give the president free rein to do whatever he wants, regardless of whether it is illegal or unconstitutional. Well, get this. We do not have kings in America. Vote no on this bill. I yield back.
We reserve.
Gentleman reserves. Members are reminded to refrain from engaging in personalities toward the president. The gentleman from California is recognized.
Mr. Speaker, I now would yield 2 minutes to the gentleman from Missouri.
The gentleman is recognized.
Thank you, Mr. Speaker. Mr. Speaker, I rise in support of the No Rogue Rulings Act. Historically, district courts' rulings only applied to the parties before the court. But over the past 15 years, district courts have increasingly asserted that their rulings apply nationwide, interfering with the legitimate Article II powers of the President of the United States. We are experiencing a constitutional crisis, a judicial coup d'etat. In February alone, district judges issued more nationwide injunctions against President Trump than against Bush, Obama, and Biden during their entire administrations. District judges from Democrat jurisdictions are preventing the president from fulfilling his duty to keep us safe. Last night, the Supreme Court called out judge shopping and reversed an order issued by a Democrat-appointed D.C. judge that blocked the Trump administration from removing violent Venezuelan drug members from our country. The Supreme Court said that this case should never have been brought in D.C., but rather in Texas, where the individuals can file individual petitions challenging their individual cases. The Supreme Court can and should rein in these rogue courts. In the meantime, the No Rogue Rulings Act rebalances the separation of powers as the founders intended. I urge my colleagues to vote in favor of this critical legislation. Thank you, Mr. Speaker. I yield back.
The gentleman from California reserves. The gentleman from Maryland is recognized.
Yes, I'd like to introduce for the record the lost history of the universal injunction, a law review article by Mila Sahoni refuting what was just stated by the gentleman. The universal injunction, the nationwide injunction, goes back at least to 1913 and has been used repeatedly over the last century. I yield 2 minutes.
Without objection.
Thank you. I yield 2 minutes to the distinguished gentleman from Georgia, Mr. Johnson, the ranking member of our Courts and IP Subcommittee.
The gentleman is recognized.
Thank you, Mr. Ranking Member. Mr. Speaker, the judicial branch ensures that people, corporations, and even other branches of government follow the law. And if a president does something illegal, which this president is famous for, the only way for the courts to prevent thousands of people from being harmed is to order a nationwide injunction that stops him from doing that illegal thing. It is essential to our democracy that the courts can serve as a check on a president who is trampling people's rights. While proponents of the bill say that each aggrieved person should bring their own case, that just does not make sense. There is no way that each of the thousands of people harmed could pay for their own lawyer, get into a courtroom, and try their own case. Aside from the difficulty and cost to everyone, our courts could never handle that volume of cases. With dockets already bursting at the seams, justice would be delayed. It would be so delayed that it would be denied. It would be inefficient, cost prohibitive, and unfair. And that is what Republicans want, because federal courts keep ruling against Trump's unlawful and unconstitutional executive actions. Therefore, they are trying to hamstring the courts so that Trump can't be stopped. We need our courts to continue to serve as a bulwark of democracy against the Trump administration's flood of illegal actions. That is why I rise today in opposition to this bill, and with that, I yield back.
Mr. Speaker,
I do have a unanimous consent request to enter into the record a April 2nd letter addressed to Pam Bondi from 500 law firms and lawyers across the nation attacking the...
Without objection, it will be entered into the record.
Thank you.
And Mr. Speaker, both Democrats and some Republicans have assailed the clearly unlawful nature of this trade war instituted by President Trump based on tariffs against the entire world except for Vladimir Putin in Russia. And Congress has the power under Article 1 of the Constitution to regulate commerce internationally. We've got the power over tariffs. The president purportedly is asserting powers under a statute which applies to emergencies in extraordinary and unusual situations. Then he said, this has been going on for decade after decade after decade. Well, then how could that be an emergency? How could that be extraordinary and unusual? There will be a lawsuit on this. And what our colleagues are saying is that if there is a bipartisan lawsuit which goes to court, which stops these tariffs that are crippling business and farmers and wiping out people's retirement across the country, and they succeed in one district, say in Minnesota or Wisconsin or New York, you've got to go to every one of 94 different districts in the country to get the benefit of that. That's what they want to do. We reserve.
Gentlemen reserved. Members are reminded to refrain from engaging in personalities toward the president. The gentleman from California is recognized.
Mr. Speaker, I did ask unanimous consent that all members be able to place extraneous material into the record. I guess they're taking me up on it. With that, I'd recognize the gentleman from Kansas for 2 minutes.
The gentleman is recognized.
Thank you, Mr. Speaker, and I want to thank the gentleman from California for bringing us this important piece of legislation. I haven't been here very long in this body, but I've learned something, and it's amplified today. and that is that this town has a remarkable ability to snatch disagreement out of the jaws of consensus. This is an issue that liberal thinkers and conservative thinkers have both said there is a problem we ought to address. Justice Kagan has been quoted widely as having said that it just cannot be the case that a single district court judge can hold up federal policy for the lengthy period of time nationwide that it takes for the ordinary appeals process to run. And on the other end, Justice Gorsuch has suggested that these nationwide injunctions bear a remarkable similarity to a step in the legislative, not judicial process. And in our branch of government, we had Democrats in both bodies of the legislative branch who proposed legislation just a Congress ago saying this is a problem, we ought to deal with it. And their legislation looked a lot like part of this bill, 3-judge panels. And now we have Republicans saying the same thing. We ought to agree this is just the right thing to do as a matter of public policy, not because of who is in the White House or who is the plaintiff bringing a particular lawsuit. Look, district courts are supposed to resolve disputes between litigants. If we adopt this thing and make it law, there's no doubt any citizen who can walk into court today can still walk into court and get relief for anything they're entitled to relief for. What they can't do is get a district court judge to order that an entire federal policy nationwide be disabled. Now, there's still a relief valve because we added an amendment in committee that allows states to go into court and seek that type of nationwide relief. Why? Because states are unique. It's not the National Association of People who lost last year's election. It is a state organized under our Constitution who have a unique role in our federal system and an interest in nationwide relief. So we ought to adopt this bill and do what everybody agrees is the right thing. I yield.
Gentleman reserves. The gentleman from Maryland is recognized.
Thank you. I yield 2 minutes to the very distinguished gentleman from New York, Mr. Nadler.
Thank you, Mr. Speaker. The Trump administration is the most lawless in American history. That is why so many of its policies are being blocked through nationwide injunctions. Republicans see this as evidence of some liberal plot among the judiciary. But the judges who have ruled against him, Republicans see this as evidence of some liberal plot among the judiciary. But the judges who have ruled against him, some appointed by such noted liberals as George Bush and Ronald Reagan, are not part of some grand conspiracy to stop the Trump agenda. They are following the law and the facts wherever they lead them. And in case after case, the law and the facts are squarely against Donald Trump and his administration. Whether it be his efforts to rewrite the 14th Amendment to eliminate birthright citizenship, or his scheme to deport immigrants without even the barest hint of due process, the courts have properly acted as a check on his power. So how do Republicans respond? Not by urging the administration to stay on the right side of the law and the Constitution. No, they simply want to make it harder for anyone to hold this lawless administration accountable. This bill would prohibit district courts from issuing nationwide injunctions even when the policies they find unlawful or unconstitutional have nationwide effects. That would be as if Brown versus Board of Education applied only to Brown. To do so would mean that no one could ever effectively check any administration's power, and no administration could ever be held accountable. The president would be a real, not a would-be dictator. This bill is a dangerous threat to the rule of law. This bill is not intended to curtail rogue judges from issuing rogue rulings. It is intended to enable a rogue administration to continue to violate the law. I urge all members to oppose this legislation, and I yield back.
And we reserve.
The gentleman reserves. The gentleman from California is recognized.
Mr. Speaker, perhaps you can just consider that every time the other side speaks, they will be speaking in violation of our rules about disparaging the president and need not say it each time, I trust. With that, I would recognize or ask to yield 2 minutes to the gentleman from California, Mr. McClintock.
The gentleman is recognized.
Thank you, Mr. Speaker. In order for the Supreme Court to issue a ruling that affects the entire nation, at least 5 justices of the Supreme Court must concur. Yet today, individual district court judges are asserting this authority by themselves. This is an outrageous abuse of public trust and judicial power, and it's opened a Pandora's box that threatens the fundamental constitutional order. The Congress is elected to make law. The President is elected to enforce it. The judiciary is appointed for the sole purpose of resolving cases and controversies brought to it by individual injured parties. Traditionally, that means an injured party seeks redress through his local district court. This simple process assures decisions are limited to the unique circumstances of the individuals involved and are restricted to cases within that district, subject to appeal, first to the circuit court and ultimately to the Supreme Court. This assures that multiple voices contribute to the development of a legal consensus before the matter reaches the Supreme Court. A single district judge seizing this authority for himself utterly short-circuits this process and does incalculable injury to our Constitution. The fact that 92% of the nationwide injunctions blocking President Trump have been issued by district court judges appointed by Democrats, many with long histories of political activism, gravely undermines the public's confidence in the impartiality of the judiciary. Now, I'm disappointed that the Supreme Court has not set its own house in order by restoring the judicial guardrails that protect us from judge shopping, from political activism masquerading as judicial deliberation, and from the usurpation of the constitutional powers conferred upon the elected President and Congress. 4 justices have signaled their readiness to do so, but without a 5th, Congress is left with no alternative but to act on its own authority, and with this bill, it does. I yield back.
The gentleman reserves. The gentleman from Maryland is recognized.
Yeah, you know, Mr. Speaker, nationwide injunctions are something that my friends across the aisle not only endorsed but took liberal advantage of in the last administration. Remember Judge Matt Kaczmarek of the Northern District of Texas? They were lining up around the block to go forum shopping in his little district, because he was the only judge, to get cases against Biden there. And then they praised the nationwide injunctions he issued. The gentleman who just spoke signed a letter in praise of a nationwide injunction that was offered by Judge Kaczmarek. So if you want to change your position, fine, but please explain to us why your position has changed since you were praising nationwide injunctions in the last administration. I yield 2 minutes to the very distinguished gentleman from Colorado.
The gentleman is recognized.
I want to thank the ranking member for his leadership, and I want to echo his remarks. It is difficult to listen to this debate, to hear the arguments peddled by my colleagues that are hypocritical at best and intellectually dishonest at worst. Where were my colleagues when 14 federal judges appointed by Republican presidents issued injunctions against policies that the Biden administration was pursuing over the course of the last 4 years? Where were you? Nowhere to be found. I don't remember my colleagues bringing this bill to the floor. Of course not. Spare me your feigned indignation. They talk of defending the Constitution when President Trump is running roughshod over provision after provision. They talk of judicial overreach as they attack judges across the country. Read the Constitution. Read the Federalist Papers. Read about the importance that our framers and founders placed on judicial independence, and reflect on what your conduct will do to the administration of justice in the United States of America, to the rule of law that has been sacrosanct for the better part of 2.5 centuries. I cannot believe, I suppose I should, but I cannot believe that my colleagues would waste time on a bill like this, a dangerous bill, instead of addressing the consequential challenges that our country faces. I would urge every colleague of mine, vote no on this bill. And I yield back.
I want to thank the gentleman for his astute observations there, and just say that Judge Kaczmarek was several times reversed by higher courts. We never came out and said, therefore, let's ban nationwide injunctions. We did say, let's reform judge shopping, forum shopping. That's the real problem. But it's not a problem if there is a nationwide crisis created by illegal action by an executive, that a judge has the authority to counter that with an injunction, and then it gets appealed up to the Supreme Court. We reserve.
Gentleman from Maryland reserves. Gentleman from California is recognized.
Thank you, Mr. Speaker. I now would ask to yield such time as he may consume to the chairman of the full committee, Mr. Jordan.
The chairman from Ohio is
recognized. Thank you, Mr. Speaker. I thank the gentleman for yielding. 677 federal district judges are just that, judges. They're not the President of the United States. They're not the person who put his name on the ballot, ran nationwide, got 77 million votes, won the Electoral College, head of the executive branch. They're judges, district judges. Said this in committee. The real question ultimately is who gets to decide. Some district judge or the guy who put his name on the ballot. Some bureaucrat or the guy who ran for the office and got elected by we the people. That's the fundamental question. And guess what? We just got 2 decisions from the United States Supreme Court which seem to reinforce that fundamental principle, that the guy who runs and heads the executive branch should make the decision. 2 days ago, the Supreme Court said they're going to put a hold on the time on this Judge Boasberg and this migrant issue that's been with us for the last 3 weeks. And then yesterday, the Supreme Court said to this unelected district judge in California that thinks they get to decide how many probationary employees work in the executive branch, not the guy who heads the executive branch. They said no to that, those left-wing groups who were seeking standing in that case. Both decisions are wins for the Constitution, wins for the rule of law, wins for the executive branch, and maybe most importantly, wins for common sense. I think I've been pointing this out since Judge Boasberg issued his order. When he said, turn the plane around, bring back the bad guys, bring back the illegal migrants in this terrorist organization, turn the plane around, bring them back, that makes no sense. Makes no sense, and the American people understand it. So I want to thank Mr. Issa for this good piece of legislation that we passed out of the committee, I think, 4 weeks ago. I want to thank Representative Schmidt, who added the good amendment to it that I think makes a good bill even stronger. And I would urge adoption of the legislation. With that, I yield back to our chairman.
The gentleman from California reserves. The gentleman from Maryland is recognized.
Thank you, Mr. Speaker. Just to answer a couple of things raised by my friend from Ohio. First of all, that's not what the Supreme Court said. The Supreme Court simply said that this was not a case that should be going through the Administrative Procedure Act under the Immigration and Naturalization Act. It should be done through habeas corpus in the District of Confinement in Texas. So, in effect, the Supreme Court affirmed that there must be due process for people who were illegally taken out of this country and sent to El Salvador. Secondly, the gentleman gives us a false choice when he says, well, who gets to decide? Is it the person who puts his name on the ballot and goes out and campaigns, or is it an unelected federal district judge? Well, decide what? If we're talking about deciding the constitutionality of a law, obviously it's the judge under Marbury versus Madison. And I know the distinguished chairman of the Judiciary Committee knows that. The fact that Donald Trump beat Kamala Harris by 2 million votes is neither here nor there. Joe Biden beat Donald Trump by 7 million votes, and they still went to court pretty much on a weekly basis to try to get Joe Biden's legislation and his program struck down. They believed in judicial review then. And so we should understand that it's very convenient for them to say all of a sudden they don't believe in judicial review just because they've got the presidency. I yield 2 minutes to the distinguished gentlelady from North Carolina, Ms. Ross.
Thank you very much, Mr. Ranking Member. Mr. Speaker, Article 3 of our Constitution vests judicial power of the United States in the Supreme Court and lower courts. The Constitution says that this power extends to all cases arising under the Constitution or laws passed by Congress. This is a bedrock principle of American democracy, and it is not up for debate. But now that the courts are blocking his unconstitutional and unlawful actions, Donald Trump wants to claim the power for himself and his administration. Trump does not subscribe to the principle of judicial review, and he doesn't believe in the sanctity of the Constitution. He cares only about himself and getting his own way. Now, Trump and his followers are threatening judges with impeachment and far worse. Bomb threats, harassing calls, and swatting all send the same terrifying message. We know where you and your family live, and you better get out of the president's way. President Trump's attacks on the judiciary are clear violations of his oath of office to protect and defend the Constitution. Mr. Speaker, threats to judges and their families simply cannot be tolerated. And members of this body have a profound responsibility to speak with one voice to condemn these reprehensible tactics. I implore my Republican colleagues to set politics aside and do the right thing. For this reason, at the appropriate time, I will offer a motion to recommit this bill back to committee. If the House rules permitted, I would have offered the motion with important amendments to this bill. My amendment would simply reaffirm the legislative branch's support for its co-equal branch and condemn attacks on all members of the judiciary. I ask unanimous consent to insert into the record the text of this amendment.
Without objection.
I hope my colleagues will join me in voting for the motion to recommit, and I yield back.
The gentleman from California reserves. The gentleman from Maryland reserves. The gentleman from California is recognized.
Thank you, Mr. Speaker. I now yield 2 minutes to the gentlelady from Colorado.
Woman is recognized.
Thank you, Mr. Speaker. I rise in support of the No Rogue Rulings Act, a bold and necessary step to rein in activist judges who have made it their sole mission to obstruct the agenda of President Donald J. Trump. Let's be clear about what is at stake. In November 2024, the American people gave President Trump a mandate to secure our borders, shrink a bloated federal bureaucracy, and put America first. He's acted swiftly, with over 100 executive orders in just 3 months to deliver on those promises that he made to the American people. But what have we seen? Unelected judges have issued sweeping nationwide injunctions to stop him at every turn. 53 lawsuits already, halting deportations of dangerous criminal aliens, blocking cuts to wasteful spending, and tying the hands of a president doing his best to protect America. This isn't justice, it's judicial tyranny. The No Rogue Rulings Act says enough is enough. It's simple common sense fix. No single district judge should have the power to grind the entire nation to a halt with one rogue ruling. Why should a single unelected judge override the votes of 80 million Americans? This is not how our Constitution was designed. The Founding Fathers gave Congress the power to check the courts, and it's time we began using it. Take Judge James Borserg's ruling last month, halting deportations of Venezuelan gang members under the Alien Enemies Act. President Trump invoked a law from 1798 to protect our streets, and one judge decided he knows better than the commander-in-chief. It's time to take our government back from the black-robed bureaucrats. I support this bill, and I thank the gentleman from California, Mr. Issa, for introducing it. I yield.
And I might note the gentlelady is referring to what has now been affirmed as an inaccurate decision by the U.S. Supreme Court. So my colleagues on the other side, in disparaging the president, keep using the word illegal. I would ask that they really reconsider. They may disagree with the executive actions of the president. From time to time, the court may disagree. But in fact, not only are his actions not illegal, they are well within the reach of what any president trying to defend the United States from enemies, foreign and domestic, might well do. We can disagree about the meaning of a law that's been on the books for 225 years. We should not disparage the motives or the actions of the chief executive simply because we disagree. With that, I reserve the balance of my time.
Gentleman from California reserves. Gentleman from Maryland is recognized.
Thank you. The Supreme Court has already rejected at least 2 of the actions that Donald Trump's taken since he got in. One was firing the the executive director of the Office of Special Counsel. He was reinstated. The other was reinstating a $2.1 billion aid grant that was essentially impounded and diverted by the administration. I yield 1 minute to the very distinguished gentleman from Virginia, Representative Subramaniam.
Gentleman is recognized.
Thank you, Mr. Speaker. Let's take a step back and be clear what's going on here. This administration maybe didn't have the votes or will to get legislation through Congress, so it created these executive orders and broke the law in doing so. Or some of these orders were unconstitutional, and that's why there have been so many injunctions to stop the law breaking. These injunctions were celebrated by the other side when they stopped actions under previous Democratic administrations, but now that President Trump is in office, this bill exists to help the president do whatever he wants, even if it's unconstitutional. And I get asked a lot these days, what's going to happen when this president ignores the courts? Wouldn't we have a constitutional crisis on our hands? Well, this bill makes it easier for the president's actions to go unchecked. And by blocking nationwide injunctions, people will be powerless to quickly stop illegal and unconstitutional actions. This bill is simply another loyalty bill for the president, up there with naming airports after him or putting his face on Mount Rushmore. Loyalty to the president should not supersede the rule of law or loyalty to uphold the Constitution. This bill doesn't just take power away from judges, it takes power away from the American people. So I urge my colleagues to vote against this legislation. I yield back.
Thank you, and we reserve.
The gentleman from Maryland reserves. The gentleman from California is recognized.
I'm going to yield myself such time as I may consume. Mr. Speaker, I'd like to bring down a little bit of the tone and remind everyone in this chamber, but speaking to you, Mr. Speaker, the chief executive, since it was George Washington, has been charged by Congress to be the first to interpret the faithful execution of the Constitution and the amazing amount of laws that have been passed in our nearly 250 years. During those decades, one after another, all the way back with Marbury versus Madison, there have been disagreements, and the court has interpreted. But those interpretations, including Brown versus Board of Education, historically became nationwide when the High Court, by a majority, ruled one direction or the other. And that is the way our founding fathers intended it to be. The ranking member of the full committee is a scholar and a teacher, a professor of this, and knows full well that we created under the Constitution a Supreme Court. And then we gave to this branch, to Article 1, to the Congress, the authority to create subordinated and specialized or limited courts. Those courts of any sort are under the Supreme Court because only the Supreme Court is to rule on the law of the land. Now, my colleagues have noted the last administration and the fact that parties, including more than a dozen attorneys general, from time to time came and asked for and may or may not have been granted nationwide protection. This bill, as amended in committee, thoughtfully amended, in fact, takes into consideration that there may be times in which multiple states are represented before one judge. And as long as that judge is the nexus of at least one, and in the case of the District of Columbia, perhaps speaks for all, he or she should rule on behalf of all the plaintiffs represented in front of them. But let it be clear, the work of the Supreme Court is not just to overturn one ruling by a judge. The court most often, in the 62 to 66 cases it takes per session, per year, rules primarily on when there is a difference between the ruling in one and the ruling in another. Rules very often because there needs to be a single voice for the law of the land. There doesn't always have to be. The fact is, if a plaintiff comes and says, I represent one of many unlawful aliens, criminals, terrorists, who have been deported under a law that has been on the books for more than 225 years, the judge has a right to rule if that defendant has a legitimate nexus in their court, has a right to rule as to that plaintiff or any others that come before him that have nexus. But to rule that the president must turn an airplane around with dangerous terrorists on it, why? Why would you do that? The fact is, judges are shopped for. My colleagues on the other side of the aisle, rightfully so, said that venue shopping has become a problem. That's not limited to Republicans or Democrats. In fact, both sides do it. As a matter of fact, Mr. Speaker, they do it in civil cases. They do it all over the place. Lawyers are very good at it. But as the chairman of the subcommittee on the courts and with the ranking member of the full committee here today, it's our obligation to fine-tune the law so that, in fact, these kinds of injustices don't happen. We're here today to fine-tune the law to protect the Constitution and the intent of Congress for more than 225 years. And with that, I reserve the balance of my time.
Gentleman from California reserves. The gentleman from Maryland is recognized.
I yield 1 minute to the distinguished gentleman from Missouri, Representative Bell.
From Missouri is recognized.
Mr. Speaker, I rise today not just as a member of Congress, but as the son of a police officer and as someone who spent nearly 2 decades working in the justice system as a public defender, defense attorney, judge, and as a prosecutor. I know what it means to uphold the law, and I know what it looks like when the rule of law is under attack. This bill is not about judicial efficiency or fairness. It's about power, raw political power. The people who once cheered nationwide injunctions when they served their agenda now want to eliminate them because judges had the audacity to hold this administration accountable. It is a direct assault on judicial independence, and many of my Republican colleagues know it. But too many who won't say it out loud for fear of political retribution or a primary financed by Elon Musk. This is not conservative, it's not constitutional, and history will remember. I urge my colleagues to vote no. Thank you.
I want to make an answer to my good friend, the chairman of the subcommittee, about the remarks he just made. He's correct that the president, of course, like members of Congress, must also interpret and enforce the Constitution. In fact, that's the core part of the president's job, to take care that the laws are faithfully executed, says Article 2. Not distorted or rewritten, but to take care the laws are faithfully executed. That doesn't negate the fact that under Marbury versus Madison, it is emphatically the province and the duty of the Judicial Department to say what the law is in the event of an actual case or controversy. The gentleman invokes George Washington. There's a beautiful portrait of Washington, the Trumbull portrait that we have in the rotunda, and it's a picture of George Washington surrendering his commission as the general of the Continental Forces, which Napoleon said made him the greatest man ever, that he could have stayed on as a dictator forever, and he gave up his power. And he could have been president forever, but he gave up his power. Now we compare that to Donald Trump, who's saying he's going to run for an unconstitutional, and yes, Mr. Issa, an illegal third term. That would be an illegal third term for him to run again to try to take office. And so that's why we have courts, in order to cabin the potentially limitless ambitions of presidents. That's why we don't have kings, we have presidents here. Secondly, I want to say there seems to be a myth on the other side that if a president campaigns on something, then it's constitutional, and the courts can't strike it down. So if the president campaigns on, and I'm going to run for a third term if I run again, then it's okay. Where does it say that in the Constitution? That can't be right. We are all bound by the Constitution no matter what we say during the campaign. The person could run around saying, I'm going to be king, or President Trump said, I will be dictator on day one. No, you will not be dictator on day one under the Constitution of the United States. So why did the judge tell the administration to turn the planes around? Because of the two most beautiful words in the English language: due process, because what they can do to non-citizens, they can do to citizens. That they can sweep anybody off the street and say, we're going to send you to a torturer's prison in El Salvador without any kind of hearing at all. It can happen to citizens as well as non-citizens. We reserve.
Mr. Speaker, can I inquire as to the time available to both sides?